Welcome to Books of Our Time, brought to you by the Massachusetts School of Law and seen nationwide. Today we shall discuss a book entitled With All Deliberate Speed by Professor Norman Silber. The book is an oral history of Philip Elman, who was a leading government lawyer and commissioner in the 1940s, 1950s, and 1960s. The book provides an insider's account spanning over 30 years of the inner workings of the Supreme Court, the Solicitor General's Office, and the Federal Trade Commission. Its author, Norman Silber, is a professor at Hofstra Law School and Yale Law School, and is with me today to discuss his book. And I am Lawrence R. Velvel, the Dean of the Massachusetts School of Law. Norman, thank you very much for coming up.
Thank you for having me.
When I was a young man, a kid, and had just come to Washington in August of 1963. From then, as long as I was in Washington, which off and on was 16, 17 years, I used to hear a rather considerable amount of times about Phil Elman. Why don't you tell people who Elman was, what he did, and how you came to write his oral history, and indeed, what exactly is an oral history?
Oral history has itself a history. It dates really from the period after World War II, when Alan Nevins and other historians realized that people were no longer writing memoirs, that in fact there was a technology that would permit them to tape record and then transcribe what they said to an interviewer, and those transcriptions would be placed in an archive for historical research. Since that time, there have been many branches of oral history, ranging from opinion research and folklore all the way to political history and the interviewing of people who were in important places or at particular events that were important. And so there's a whole spectrum of oral historical work, and one of the leading places at which that work takes place is the Columbia Oral History Center, which is, I think it's now called the Columbia University Center for Oral History. And that's a leading center for oral history.
You said one thing that piqued my interest. Why did people stop writing memoirs?
I think that there was a tradition of keeping journals that disappeared. I think it disappeared after the telephone. I mean, people used to converse by letters and write journals at night, and particularly it became evident to people who were writing political history first, I think, that those sources were drying up.
Yeah. How did you come to write the oral history of Elman, and what was the process you undertook in writing it?
Well, I had been doing oral histories and taught oral history as a subject matter when I was a college teacher. And I received a letter from two associates at a law firm called Wald, Harkrader, and Ross, and they approached me with a cold letter to me, actually, asking me if I would consider doing an oral history of a person they considered to be worth spending time with because of the positions he'd held. And he'd recently had health problems at the firm, and they felt that this would be something that would be worthwhile to do as a historical matter, and also I think they thought that it would be something valuable for themselves, because they were very much impressed with him.
He was a member of the firm or counsel to the firm?
I think he was of counsel.
Yeah, so he had some position with the firm. What had he done before that they knew that he had been a leading figure? Well, what is it that he had done?
This was, of course, at the end of his career.
This was in the 80s.
In the 80s, and
yeah.
he'd had a life full of active lawyering. He'd been a law clerk to Supreme Court Justice Felix Frankfurter. He'd been a part during World War II of the denazification program in Germany. He had gone to the Solicitor General's office, and he'd gone to the Justice Department, and he was a Justice Department lawyer who essentially created the Civil Rights Office at the Justice Department Solicitor General's office and handled all of the civil rights litigation, essentially all of it, up until he left.
But the people in the SG's office do nothing but brief and argue Supreme Court cases. So everybody wants to be there.
It was a very elite office. It continues to be.
In a profession which is overrun entirely by conceptions of elitism, it stands at the pinnacle of the conception, I guess one might say.
I think at the time that we're talking about, it did.
Yeah.
I'm not able to speak to what it's like today. I think today actually the Solicitor General doesn't quite enjoy the position in the Justice Department. He may be the number 3 person instead of the number 2 person in the Justice Department. But nevertheless, it continues to be quite an august institution almost within the Justice Department.
There was a time in my life, Norman, when despite our political differences, which were polar, I was very friendly with and worked a great deal with Robert Bork. And Bob used to tell me, and he makes no secret of it because he's written about it, how the word came down to him that he had to fire Cox. Because I think both Richardson and what's his name, I've forgotten the other fellow's name, they had passed, thank you very much, and resigned. And so he was number 3. And he said, look, if I hadn't done it, the department would have fallen apart. And he may have been right about that.
Yeah. He just passed away.
Pardon me?
Robert Bork, as we speak, just recently died.
Yes. Explain the format of the book that you used and why you used that format. And given the nature of the format, the portions of the format which could be described most basically as Phil Elman's and the portions which could be described most basically as yours.
A typical oral history transcript contains the interviewer's questions and the interviewee's responses, and that's pretty much it. And for 2 years I interviewed Phil and we produced transcripts of that sort.
And each transcript ran about 400 pages?
Yes.
Yeah.
And we met for about 2 years. We'd meet in his law offices in the library of the law firm, and we would tape record our conversations. And the transcripts were typed at the offices of the oral history office at Columbia University. Then they would go back to me for editing, and then back to Phil for editing, and then they would go back to the library. And then after we were all done, he worked further on them, and he did polish them, and I worked with him on the polishing of them, and then he signed off with a release, and that was the way that they came. They first emerged as a book. Interestingly enough, when we tried to publish that transcript and simply that product, it pretty much went nowhere until I experimented with the form. There was originally, and there came to be a Harvard Law Review article which was just about the civil rights portion of the interviews. That stirred up a hornet's nest. He died, and after he died, I asked his widow for permission to go back and work further with the transcripts, which she gave me. And I developed what I call an uninterrupted interviewee's narrative with a transplanted and amplified interviewer's voice.
Yeah.
And that's pretty much new in oral history, or pretty much not.
And at the end of each chapter, you have many notes that elaborate and explain what is talked about in the transcript itself, on the theory that, and it's a very good theory, it being so many years, 40 and 50 years from some of the events that Elman was talking about, people often won't know who the individuals are who are mentioned or what the events are that were mentioned, and yet they're of the essence both to Elman's life and career, and in cases like Brown versus the Board of Education, to American history.
There are some types of oral history that don't require validation or elaboration. For example, folklore, by and large, if a person lives with a myth, that myth is something that is worthy of conveying to the public. I think with the oral history of a lawyer, or legal oral history, there's a certain responsibility the interviewer has, I have, to not only validate or try to validate what the person's saying, to authenticate it, and to do further research. So the comments at the end of each chapter, I divided the transcript and I edited it, and I decided to do a lot of independent research in order to find out more about the things he had talked about.
Well, it shows. It just so happens that because I was in Washington in the 60s and 70s, a lot of what Elman and you talked about I knew, but I think most people wouldn't, and there was stuff that I didn't. So, it proves very valuable. You have in here some quotes from a brief that Elman wrote in, I think it was the Henderson case. And I must say that that is among the most beautiful writing that I have ever read in a brief. And the point always was that he was a fantastic writer, absolutely a fantastic writer. Would you mind reading the bottom of page 2 and the top of page 3, which is what you're quoting here is from what Elman wrote. And this is 65 years later or so. And yet, this says it all as to what had to be said in those days, and nobody else is really saying.
This appeared in the brief that you're talking about in Henderson against the Interstate Commerce Commission, which is a 1950 case.
Right.
And I think it's accurate to say that it was the first brief filed by any party in front of the court since Plessy that squarely and directly asked that Plessy, which was the case that stood for separate but equal, that case be reversed.
That was 1896.
That was an 1896 case.
Yeah.
And so it was the government in Henderson, and it was Phil writing the brief.
Yeah, because a gentleman couldn't eat as I remember, he couldn't eat in the dining car.
This was a government employee who was an African American who was denied service in a dining car because the table at which he would have sat was occupied by whites.
Right.
And there was a curtain, and he went back to his dining car. He went back from the dining car having not been served. He later brought a suit. The case was extraordinary because the Interstate Commerce Commission responded by saying that those are separate but equal is a policy of and the Commerce Commission supports the policy, and it is the law of the country. And they won below, and they won at the appellate level, and then it came to Phil's desk. And Phil looked at this and he said, "This is wrong. This is just not right." And he convinced his superiors to that they should confess error. We'll talk about maybe confession of error.
Well, for the layman, that means admit that we were wrong all the time and rule against us.
Yes. So here the Interstate Commerce Commission had won below, and now it gets to the Supreme Court. And the Supreme Court's the lawyer for the government says, "No, we're not going to argue that in the Supreme Court." And so the ICC had to argue it itself.
Right.
And Phil, representing the Solicitor General, wrote the brief, and the brief said, "Segregation of Negroes, as practiced in this country, is universally understood as imposing on them a badge of inferiority. That type of segregation imposed by the railroad's regulation is humiliating to those subjected to it. That it is so obvious as scarcely to need documentation. This message of humiliation comes not as a single voice, but with all the reverberations of the entire pattern of segregation and discrimination of which it is part. It's bad enough for the Negro to have to endure the insults of individuals who look upon him as an inferior. It is far worse to submit to a formalized and institutionalized enforcement of this concept, particularly when, as in this case, it carries the sanction of an agency of government."
That's probably the finest writing I've ever read in the civil rights field. And it was among the earliest.
Yes, it was.
Yeah, I mean, that's amazing stuff. That's amazing stuff. I mean, that's social justice writing. How did Elman come to be such a proponent of social justice?
It's an interesting background because he really came from very modest roots. He was born in Paterson, New Jersey, in 1918 in the house of his parents. Patterson at the time was a silk weaving center, probably the silk weaving center of America.
They'd all come from Białystok or somewhere.
They'd all come from Poland. There was a couple of towns in Poland, and they literally transplanted themselves to Patterson.
Yeah.
And
which is the same name as the guy in The Producers.
And I should say that part of Eastern Europe was itself a seat for a lot of radical thinking and a lot of socialist thinking.
Yeah.
So that his father might well have owned a couple of looms, but he was very much identified with a traditional Jewish socialist
small businessman
causes.
who identified with Jewish socialism.
Yes.
Very common story.
Yeah, yeah. And they would read things like the Jewish Daily Forward, or and his father belonged to the Workmen Circle.
Right.
So this was a fairly traditional story about what was going on, and the family subsisted pretty much, even though his mother, Phil remembered fondly that his mother made wonderful meals and that they never felt poor because she cooked so well and so forth. But they really didn't become secure economically until one of the people in the family, I think it was an uncle, who after Prohibition managed to get a license to sell liquor at a package store.
Right.
And Phil, growing up, worked jobs, and his father just basically working in a package store.
To be able to sell liquor was a license to coin money. So anyway, he came from that kind of a socialistic background, and he went to CCNY. Another typical story. It's become made famous because the Nathan Glazer was there, and Irving Kristol, and Daniel Bell, and a whole bunch of guys who became leading intellectuals in this country. And it was famous for people arguing in the alcoves, and blah, blah, blah. And then he went to Harvard, and Harvard Law School was a real revelation to him, wasn't it?
Yes. He said that, his education at City College had pretty much prepared him for hard education, although he says he was a loafer. He said to me that he really never had to work very hard because things came easily to him. But when he got to Harvard, all they did was work.
Yeah.
When he got to Harvard, he was scared to death because Harvard was a place that flunked people out.
In those days.
It was. There was a guy named Bull Warren who was the role model for the later
Professor
films.
Kingsfield?
Kingsfield,
Yeah.
yes. And look to your left and look to your right, and one of you will be gone. Phil said he doesn't actually remember the story, but there were plenty of legendary stories at the time about Warren having told some student to leave the class because he would never become a lawyer. And the student turns around as he's leaving. He says, I'm leaving, but I've got to tell you, Professor Warren, to go to hell. And Warren says to him, wait, come back, maybe you will be a lawyer after.
And that was true. That kind of stuff was true in just about every law school in those days. I don't know, maybe not at Yale, but the world began to copy Harvard Law School around 1905 or so, and that kind of browbeating of people was true.
Well, it's interesting. If you go back, I read Warren's book, Spartan Education, and they designed, this is probably something that many people here know, but Harvard was not designed to be a comfortable existence. They designed the rooms to be harsh, and they designed the education to be difficult precisely because they believed you were doing a disservice to a student by suggesting that the world outside was warm and fuzzy and charitable and would forgive you for any mistakes you made. And Harvard was...
that would be an argument which is in full flower today. It's a good buddy of his at Harvard came from the complete other side of the tracks. His name was Robert Stanfield.
Yes.
I don't remember whether he became Premier of Canada or he merely lost it to Pierre Trudeau. And they were just as close as can be, and they'd pal around Boston together and all that kind of stuff. Wow, I mean, this is the devil in the deep blue economically.
So he's a Harvard student, and he's rooming with Stansfield, who does become the leader of the Conservatives in Canada, loses to Pierre Trudeau, exactly right.
Yeah.
Yeah, and And he says the two of them would sort of, well, you know, you go through law school, I've been through law school, you develop buddies and you work with them hard.
That's true. It's absolutely true. I'm going back to a reunion, our 50th reunion, and my closest friends in the world are coming back. We're all going back at the same time.
Yeah.
This has been going on since 1963, and with some of them since 1957. In any event, explain how he went to work as a clerk, the circumstances that caused him to go to work as a clerk for a famous federal court of appeals judge named Calvert McGruder.
Well, in his third year, he had been a McGruder student. McGruder was appointed to the Federal Court of Appeals. Well, McGruder actually had been sent off to Washington and took a leave from Harvard. I don't think actually Elman ever took a course from McGruder. Instead, he'd been hoping to, and McGruder played a major role in drafting labor legislation, and then he was appointed to the Court of Appeals. He needed a clerk. He knew Elman, and many of the other clerks had already been taken. Elman had graduated very high in his class, but he wasn't an officer on the law review. So what Phil told me was that he was good, but he wasn't good enough to get a Supreme Court clerkship.
You know, that was baloney. That was just false modesty.
You think?
Well, I mean, that's my opinion, because by that time he knew how good he was.
Well, the Supreme Court clerkships were given out on a very, I mean, first of all, there weren't all, not
you
all
only
of
had one clerk per judge.
Right, and not one clerk per judge, and not all the judges took Harvard students.
Oh, yeah, okay.
So the number was, as good as he was, it was not a shoo-in. But he did get recommended by Frankfurter, by the dean, and by Ed Pritchard, who was was in front of him, and so he became McGruder's very first law clerk.
You know, Pritchard or however you pronounce his name, you cannot read a book about that period in American history in Washington, D.C. without reading about him. And I guess, because he must have been some shakes, is all I can say, because no matter how famous, whether it's Phil Graham, who ran the Washington Post, or Elman or whomever, they all talk about him. And Brandeis, wasn't he Brandeis's clerk? Frankfurter's clerk. He went back to Kentucky. They thought he'd become governor and president, and he made the most horrendous mistake imaginable. He filed a fraudulent voting return.
Yeah,
He
disbarred.
went off to the slammer, I guess.
Went to jail, disbarred. He ended up redeeming himself in many respects, educational work in the state. But they all considered it a tragedy. Everybody who knew him considered him to be one of the great raconteurs, sense of humor.
Yeah.
Yeah.
They say you can hardly read about those days and not read about him. And here the guy just threw it all away. In those days, you point out that McGruder, I don't know whether this would be considered appropriate today. When he had cases, he would discuss the cases with the professors at the Harvard Law School.
I think it's fascinating that, and especially in light of what happened later to Phil.
Yeah.
The fact of the matter is that McGruder had come from the Harvard faculty, and when he had a difficult case, he felt no compunction about talking to other faculty members about how to resolve the case.
Yeah.
Of course, that would later get, I mean, in the modern era, that has gotten judges into deep hot water.
Yeah.
But of course, Lord Mansfield, you know, the peppercorn, you know, one of the things that the historians who talk about the birth of commercial law in England point out that one of the things that made Mansfield great was he tested his theories on real commercial actors.
Really?
Yeah. So, you know, how should I decide this case?
Yeah.
What should I do? And there are a couple of civil procedure cases that Phil told me about in the book, in the oral history, that in which McGruder would really hone the opinion by asking experts on the Harvard faculty about the right
you mentioned
outcome.
something about a case which I don't want to get into because it's too difficult for lawyers, let alone for laymen.
Yeah.
A case involving Erie Railroad
Sam's.
versus Tompkins, and oh my God,
Yeah.
you know. So one can almost understand. Then Elman went to clerk for Justice Frankfurter, And tell what that was like, both for Elman and for Frankfurter. Let me say at the inception, Frankfurter was the world's biggest busybody, was he not? He knew and talked to everybody, whether they were in courts, in politics, in business. Nothing was off. Guys who should, by our lights today, should not have been within 10 blocks of the court, used to be in his chambers talking to him. I mean, he was a raconteur, a man about town, and, you know, Elman wasn't any of these things, really. So, in a way, it was, you know, the devil in the deep blue, but it was a lot deeper than that.
Frankfurter had a by-invitation only seminar at Harvard, and invitation depended mainly on grades. And Phil was invited into the seminar, and that's where the relationship between Frankfurter and Phil began. Phil remembers himself as being completely silent. I have trouble believing that entirely because Frankfurter took a shine to him, and Frankfurter later took him then as his clerk. And there's a story there about how that happened. He was originally going to be a different Supreme Court judge's clerk, but he ended up with Frankfurter. And he was his only clerk for 2 years during World War II. So that would be 1941 to 1943. And that's rather extraordinary. Part of it relates, of course, to the war.
What was extraordinary? That it was only 2 years, or that
it was
2
2 years?
Pardon me?
Right? That it was 2 years.
That it was 2 years, yes.
That it was 2 years is unusual.
Yeah.
I think he was his
Standard
only
is 1 year.
1 year, and I think he was Frankfurter's only 2-year clerk.
Okay.
Among other
Okay.
things. And of course, Frankfurter had no children.
Right.
And during those years of war, being a Supreme Court judge was only a part-time occupation, as you're suggesting.
Yeah.
It was those were years when Frankfurter apparently went to war.
Yeah.
And he had, as you say, during the New Deal, he'd been appointed during the New Deal, and he had sent student on student into the New Deal. So, in fact, so much so that William Leuchtenberg and others have talked about Frankfurter's hot dogs. You know, they became known as Frankfurter's hot dogs, and a generation of Harvard law students went into government.
Right.
Government lawyering became an attractive, exciting area to practice in, just as in the 20s it had been Wall Street.
These guys were all over town. They lived in houses together, 7 and 8 and 10 to a house, and the houses became individually famous. And they would have huge parties all the time, and the women were thronging there, and they were doing some of the most interesting work in the New Deal period.
My most immediate concern is in carrying out the purposes of the great work program. The first objective is to put men and women now on the relief rolls to work.
Massachusetts School of Law. Legal education that is practical, accessible, affordable, and enjoyable. Offering flexible day and evening classes, full or part-time studies, where candidates are assessed not on the LSAT, but their academic and other accomplishments. Providing more professional skills training than any other law school in New England. Massachusetts School of Law. Visit us at mslaw.edu. Training students to become successful lawyers and advocates, not just legal scholars.
Phil Elman said, I gather, he never really knew who it was that was coming over to the court to speak to Frankfurter, because Frankfurter's office was at, as I gather, one end of the suite of 3 offices. Phil's was in the middle, and the secretaries were at the other end. And so people like George Marshall and famous military people, famous government figures, they'd walk directly into Frankfurter's office, and Phil would never know, except if Frankfurter wasn't there, Phil would have to entertain them.
That's what Phil said, and Bruce Murphy made a large historian made a large amount of mileage out of that fact, and Phil took some umbrage about it because he felt that was misinterpreted. But essentially, what Phil told me was that Frankfurter was very jealous about his time. He was very jealous about Phil's time, and that Phil had certain things to do when he was clerking for Frankfurter. Particularly, Frankfurter saw his strength in writing. Phil did a lot of drafting, and Frankfurter did what he did, which was a lot of meeting with high-level and low-level people.
Yeah. Well, you make the point that as opposed to the last 20 years or so, or last 30 years, when conceptions of ethics and propriety have changed dramatically, I think. In those days, everybody in the country was at war. And Frankfurter, who felt a lot for the country because it had taken him in as an immigrant and made him into permitted him to become a famous man, whatever one thinks about Frankfurter. He was very much, loyal's not the right word. He loved the country and loved what it had enabled him to do. And so he was deeply involved in everything during the war. But you make the point, so were a lot of other justices doing things. Douglas and
That's right.
I don't know who all, but several of them were.
That's true. Phil said everything changed after Pearl Harbor. He said that Sunday morning, December 7th, 1941, was a kind of a watershed for many people across the country, and particularly in the chambers of Felix Frankfurter. He said, you know, Frankfurter took him aside and said, we're now at war. Life has to be a little different now. I'm going to be doing things to help the war effort. And Phil was 4F. He had a bleeding ulcer,
Yeah.
which he had, which had popped at Harvard during his first
Oh
year
yeah,
exams.
Harvard's attributable for a lot of that stuff.
And so Frankfurter divided up the work. Frankfurter would review all the cert petitions. Most of the other law clerks reviewed cert petitions for their justices, not Felix Frankfurter. Frankfurter would read them all through and decide, apparently in a zip, zip, zip manner.
Can I interject something for the
yeah,
benefit of the audience?
Yeah.
A cert petition is a short brief. It's usually no longer than 10 to 15 pages, in which the party that lost below tries to convince the Supreme Court that it should hear the party's case. And as I say, they're very short, but to this day, clerks spend an enormous percentage of their time reading these and writing recommendations on them. And it was true then, it's true now, but not in Frankfurter's office. Frankfurter's, you say, oh, zip, 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 you could tell immediately. And Phil's time was too valuable, you said, to be wasted on that, so Phil was writing opinions.
That's right. That's right.
You know, that is so outlandish to people who know how the Supreme Court works today. One hardly knows how to react to it. But, you know, Frankfurter, he knew what he was looking for.
Well, yes, and in some ways, maybe he didn't want to screen. You know, he didn't want to screen between himself and those cert petitions.
Yeah. Well, I suppose one of the really interesting things that happened in the war in the Supreme Court was the two flag salute cases involving Jehovah's Witnesses. Frankfurter wrote the first opinion saying that a state government could require the Jehovah's Witnesses kids to salute the flag, and within a year or two, another case came up and the Supreme Court took it and they overturned the first case. And that was a major thing, so to speak, with regard to Frankfurter. Talk about those cases a little bit and what it meant to Frankfurter and to other people with whom Frankfurter was in contact.
In 1940, a case came to the court called Minersville against Gabaitis. That case involved free expression and free exercise of religion. It involved the compulsory flag salute. And in that case, Frankfurter wrote the opinion, and it was a case in which Justice Frankfurter, speaking for the large majority of the court,
perhaps all but one?
All but one, I believe, wrote that an attachment to the institutions of the nation would be inculcated by the flag salute. There was a legitimate purpose to requiring the salute, and therefore the state law requiring the salute was constitutional.
The kid, I pledge allegiance. Did you have to do that?
I did. I didn't think it was required of me, but,
Well,
but it was.
I did.
It was,
We grew up in different areas, I guess. But anyway, so go ahead.
So Frankfurter wrote that a court had to defer to the reasonable judgments of a legislature, and in many ways that was consistent with a New Deal justice of the court who was interested in protecting the New Deal legislation of the day.
Yeah.
So for Frankfurter to take the position that the court should defer to a legislative enactment absent some other compelling justification or reason, and he felt that the religious claim, the claim of free expression, was not compelling in the case.
I take it that from the standpoint of the Jehovah's Witnesses, I wouldn't say this was like a golden calf or a graven image, but I don't know, maybe it was. You don't bow down to the representations of the works of man. I mean, do I have this roughly right?
I'm not an expert on
Anyhow, they didn't
Jehovah's
want to do it
Witnesses.
for religious
They
reasons.
felt, yes, they did feel that it transgressed their fundamental religious
Yeah.
principles in
Yeah.
order, if they were being asked to subordinate God to the state. And that's what they felt they were doing. The only person who dissented in that case was Harlan Fiske Stone. And yet, within 3 years, another case, almost identical on its facts to that case in Gobitis, came up, and that was Barnett against West Virginia, and that occurred during the clerkship of the period that Phil was clerking for Frankfurter. And Phil told me that in that short period of time, and this is part of history, Frankfurter lost his majority on the court. And there was such a switch that now Frankfurter writes the dissent because Hugo Black, William Douglas, and Frank Murphy switched their positions to create a majority along with Stone, Jackson, and Rutledge. So now we have Frankfurter, who had previously written the majority opinion, and now he's caught writing a dissent. And it obviously is disturbing to Frankfurter, and many people think that this is the beginning of a rift on the court between the Roosevelt appointees. And President Roosevelt had an opportunity to completely reshape the court over which he did. So Frankfurter dissented, and when he dissented, Phil essentially worked with him in writing that dissent. And Phil describes in the book, you'll see the description of Phil, who said that whenever he shaved or whenever he would, whenever he'd go to the kitchen cooking, Frankfurter would think about the opinion and the dissent he'd write. He'd write little things on little notes of paper, and he would stick them in a drawer.
Yeah, right.
He would stick them in a drawer.
It's like the proverbial guy who gets up in the middle of the night.
Right. He gets up. He has an idea. He sticks it in a drawer, and then he lets it sit for a while. It's percolating in his mind, and the other justices, the majority opinion's been written, and they're waiting for the dissent to emerge. And Frankfurter is stalling and stalling. When are you going to write this dissent? And Frankfurter, I'll get to it. Don't worry. And Phil says, I tried to nudge him to get to write this dissent, and it was very delicate. And finally, one day, Frankfurter comes to him and says, we're going to write the dissent today. And so he says, get your drawer. He pulls out all of these scraps of paper, and he starts dictating them to Phil, who puts them on paper, and they do a lot of back and forth and cutting and pasting. But in the midst of it, there is the statement that says, one who belongs to the most vilified and persecuted minority in history is not likely to be insensible to the freedoms guaranteed by our Constitution. Were my purely personal attitude relevant, I should wholeheartedly associate myself with the general libertarian views in the court's opinion, representing as they do the thought and actions of a lifetime. But as judges, we are neither Jew nor Gentile, neither Catholic nor agnostic. We owe equal attachment to the Constitution, and we're equally bound by our judicial obligations, whether we derive our citizenship from the earliest or the latest immigrants to these shores, right? So he opens up opens it up, and
Which was beautiful writing, by the way.
it is beautiful
It
writing.
caused havoc, but it was beautiful writing.
It is beautiful writing. Phil Elman told me that he just was aghast. He said, Justice Frankfurter, you can't do that. You can't do that. You who have spent your career arguing that these things are not relevant to your judicial work are now raising it in the process of denying that they are relevant, and this is completely inappropriate. Of course, in any fight, and I've been a clerk to a judge, any fight between a judge and a clerk, we know who's going to win. And essentially, Frankfurter, of course, prevails, and that statement goes on throughout in subsequent.
I may be the only person in captivity who thinks that was a perfectly appropriate comment, because I think what he was saying is, look, I'm a member of a persecuted group, and yet I say that the government has a right to do this, which struck me as perfectly logical. But as you say, he caught holy hell for that all across the landscape. It was, what can you say? It was just something that people thought should have been left out.
What I think Phil would say about this was that as a justice and throughout the subsequent relationship, he said that Frankfurter was a scrapper. There was no. He would bring out anything that he thought would help him to win an argument. And although Frankfurter preached disinterestedness, it was not practiced as much as it was preached.
I cannot tell you, Norman, how many people I know of every race and religion and creed who will say anything to win the argument. It's a pretty common thing.
James Simon has a book called The Antagonists, in which he talks about Frankfurter's upbringing, and he debated from a very early age. He was and he reveled in debate. And
right. Later years, there was another problem that arose in a case of, frankly, in terms of world shakingness, maybe even more importance, Youngstown Sheet and Tube versus Sawyer.
Yeah.
And the argument there was, you see, I'm leaving something out here. We discussed that Frankfurter was in touch with everybody, with Roosevelt, with Marshall, with senators, Jimmy Burns, who had when he left the court to become a big shot in the administration, and they all were in his office, and he was always facilitating things and this and that. And that brings up this situation with Vincent in about 1951, I think it was, when Vincent told Truman, you can safely seize the steel mills, which led to the famous case of Youngstown Sheet and Tube versus Sawyer.
Right.
And what was Frankfurter's position, or what did he think about that?
It was the eve of a steel strike, and Truman issues an executive order, and the executive order directs the government to take possession of steel mills.
That was because we needed to steel for the Korean War.
Right.
Yeah.
Right. 1952, and so Frankfurter thought, well, Vincent was had been appointed by Truman,
right,
to the court, and Truman apparently asked Vincent for an advisory opinion, right, as to whether this was constitutional. And
right,
of course, Frankfurter and the other justices were appalled, because this is reminiscent of when, in the Dred Scott era, when Taney was asked for an opinion by Buchanan, right, of the constitutionality of the fugitive slave law, and these things are I mean, this is not a role for the court.
Yeah.
So Frankfurter was just appalled. It irked Vincent that his colleagues were appalled.
How did they know about? How did the colleagues know about it? Do you know, Norman?
I'm not sure how they knew about it.
But it just became sort of general knowledge.
Yeah, I think so. I should say I don't really know whether it became general knowledge or whether or not it was actually published. I mean, whether Vincent actually said it had happened.
Wow. And of course, Truman lost that case, and I would judge it's one of the, I don't know, pick your top 5 or 10 cases in American, most important cases in American history. That's one of them because it placed brakes on executive power. Brakes which have been largely forgotten, some would say, but you know, anyhow, it was a very important thing. And you know something else that fascinated me about Frankfurter? Now, I'm a Jewish lawyer from Chicago. Frankfurter's opinion about my kind of people, I mean, I just think it's appalling. He wrote a note, you say, down to Elman sitting in the audience about, can you believe these big mouths from Jewish lawyers from Chicago, or something to that effect?
After Phil has clerked for Frankfurter, he's in the Army for a little while and does some things in Germany. Then he comes back and he gets a position in the Solicitor General's office. And it's almost like having a box seat at a theater because the Solicitor General sits frequently, and especially the Assistant Solicitor General, as Phil was the Assistant Solicitor General. You sit in the Supreme Court, you have a regular seat, and you watch the proceedings.
Right. And
here is Felix Frankfurter on the bench, and there is Phil, and Felix sends him notes, regularly sends him little notes.
Yeah, you brought a couple of them here.
Yeah, I brought a couple. So one day he sends him a little note from the bench that says, I note the presence of a great barrister from the Windy City. Why are so many Chicagoans unappetitlich?
Yeah.
Why are so many of them unappetizing? You know, and there's a poor argument by a Chicago lawyer, and Frankfurter drops this note down to Phil that says, listening to one of the greatest leaders of the American bar. Don't you know you're doing that, Phil? Or maybe at least the Bar Association.
I looked it up just to be sure. So I found out who these people were. And they were not Robert Stern, who of course was, you know, very famous, from Chicago, head of the SG's, the leading civil servant, I think, in the SG's office, and highly reputed. And it wasn't somebody else I knew either. I've known a few Chicago lawyers in the SG's office, like Steve Shapiro of Mayor Brown and Jack Levin. Chicago is the only city in the world where they pronounce it Levin instead of Levin, who was at Kirkland Ellis. I mean, just absolutely wonderful guys, you know. Anyhow.
Maybe it was the accent.
Yeah, they didn't have one. I still have traces. I can hear it. A lot of other people can't hear it, but I can still hear it.
I think those notes speak to this relationship between Philip and Felix, and it's quite a close relationship.
Phil was in Germany, played some part in the effort to denazify Germany, an effort which is described in the book as largely unsuccessful because there were too many Nazis. You know, they figured they might be able to handle it if there was 8,000, but there was 40,000 or something like that.
Yeah.
And that was just too much. Anyway, he came back. He got involved in the Solicitor General's office. I guess he was working in the State Department or somewhere. And Frankfurter told the Solicitor General, a fellow named Charles Fahey, that I have this very, very bright guy, Phil Elman, and he's doing nothing over wherever he is. So Fahey called him and says, is this true? And he said, yeah, that's true. And he said, okay, there's a stack of briefs. I have to get busy. Yeah. And that's how he got into the SG's office, where he became, in that milieu and in that time and in that city, he became extremely well known. I mean, when I came to Washington, I never met Phil Elman. I heard about him all the time. One of the first things, I guess, that he got involved with was a case named Shelley versus Kramer.
That's right.
Sounds like it should be a movie star in Las Vegas, but it's actually one of the most important civil rights cases that was ever decided. So if you would elaborate on how he got involved and what happened and what Shelley versus Kramer was all about.
Phil comes back from Germany in 1946, and he rejoins the Solicitor General's office because he'd been there. He went to war and he came back. He comes back, and 1946 is a year when civil rights becomes something of a topic of interest.
The African American community had been fighting for civil rights since the time Jim Crow began in about the 1890s. And it had been a losing battle pretty regularly. Occasionally some good things happened, like when they saved the Scottsboro boys from the electric chair for a rape they did not commit, 8 of them or so. But it was pretty much a losing battle. But after the war, the very fact that we had fought Nazi Germany and the grounds on which we had fought it, and what the Nazis had been doing, this caused a sea change in the conversation. When the camps were discovered, Eisenhower, who was a much brighter guy than a lot of people have given him credit for, I think, said, well, our men, it has been said our men do not know what they are fighting for. Now they know what they have been fighting against. So things changed because of the war.
Well, there were executive orders during the war that, for the first time, integrated aspects of the service. In 1946, Truman appointed a commission, and that commission produced a report. And the report itself generated the thought that more could be done about civil rights. And Phil was very interested in the report, and there were recommendations for extending civil rights protection that were in the report. Phil met a lawyer named Phineas Indritz in the Department of Interior. And the two of them,
one of the little
unsung
important
hero,
figures of history.
unsung hero of the civil rights movement. Later, I think he played a role in the women's movement. And he was in the Bureau of Mines, but Phil and he basically cooked up the idea that they would generate a flood of letters from organizations around the country, civil rights groups and others, asking the Justice Department to take up and join the move against discrimination.
He's a master PR guy.
Yeah. Indritz knew the Secretary of Interior, Oscar Chapman, and was trying to get discrimination among the Indians addressed. Chapman wrote to the Attorney General asking the Attorney General to file an amicus brief in those cases. And Indritz drafted the letter, and Chapman signed it. And then the letter came over to the Department of Justice, where it ends up on the desk of Phil Elman. And
surprise, surprise.
Right. And this is before there's a Civil Rights Division. And there had been a Civil Rights section in the Criminal Division, which had worked on involuntary servitude issues and voting rights issues. So Phil, at that point, has friends in the NAACP. He's got friends in the American Civil Liberties Union. He's got friends in the American Jewish Congress. He's got friends in a lot of different organizations. And he gets them all to write letters to the President and letters to the Attorney General, urging the government to intervene in the Supreme Court. And those letters wind up on the desk of Phil Elman. He gets the State Department to write a letter to the Attorney General expressing concern about discrimination in the United States and the impact on foreign policy. Incidentally, there's a woman, a fine scholar at UCLA, Mary Dudziak, who has taken this and run with it and written a lot of interesting work about the civil rights movement as a Cold War imperative.
I can remember it being raised when Kennedy was president.
Yeah. So, I think there is a lot of strength in the argument that we look bad overseas in countries we cared about because we had a society that
You know a funny but true story?
was segregated.
After the war was over, they asked some people in a small English town what they thought about those American boys, the soldiers who'd been quartered among them. And they said, oh, they were wonderful. And some of those white boys were okay, too.
This is near Truman's re-election, or election, I should say. He's not doing very well in the polls, and they're politically minded, and they're thinking about the vote. Suddenly, there is an impulse in the Justice Department to do something about civil rights. And so the Solicitor General at the time is Perlman, and Perlman tells Phil to draft a brief supporting a claim against restrictive covenants, and that's this case of Shelley against Kramer, which is a very important case in the line of cases leading up to Brown versus the Board of Education.
The restrictive covenants were very importantly enforced against both blacks and Jews. And they kept whole areas of cities and suburbs pretty much lily white and Christian. You know, it's hysterical to think of it, but I can remember when I was 10 years old. My brother had passed away, and so my family couldn't live in the same apartment in Chicago anymore on the west side because, you know, just too filled with memories. So we went looking around on the north side of Chicago and the suburbs for a new place. And we were on this street. I don't remember what street. There was one house, a whole block. Nothing but a prairie. And a whole block. And this was in Skokie. One house.
My hometown.
Oh, is it?
Yeah.
Okay. And my parents look at it and they say, you know, well, why don't we look at that? It's for sale. No, you can't look at that. They don't allow Jews here. Skokie. That actually happened.
Wow.
All right.
Yeah, well, just the irony is that when my parents bought their house in Skokie, it had a restrictive covenant in it.
Did it? But you couldn't, by that time, I'm sure you couldn't enforce them anymore because
That's
Shelley
right.
had been on the books for years.
It had been on the books and it was unlawful, but it was
Yeah.
it was in the covenant. It was in the
Yeah.
contract.
That actually,
yeah.
anyhow, okay. So Perlman did that, and Phil wrote the brief, and they won the case.
They write a brief, and it's a showing the flag, as Phil puts it, a showing the flag kind of a brief.
Yeah.
150 pages, laying out the position of the Truman administration to do something about the problem of restricted housing. And what's interesting about that, I think there's an ironic aspect to that anti-discrimination position of the Truman administration. Phil tells me that when they drafted the brief, they put the name on it of Tom Clark, who was the Attorney General at the time, which is unusual because Attorney Generals don't usually sign
Right. This was a way of
briefs.
signifying to the court.
This was a way of saying it was a major interest of the government of the United States.
Yeah.
They put the name of Philip Perlman, who was the Solicitor General, of Philip Elman, who was the Assistant Attorney General, and of the other attorneys who had worked on the brief, Hilbert Zarki, Oscar Davis, Stanley Silverberg, who were all special assistants to the Attorney General.
Yeah.
And it goes to another member of the Justice Department, Arnold Raum, R-A-U-M, who is Jewish, and he crosses off the names of the last four signatures on the brief. And he says to Phil, it's bad enough that I have to have Perlman's name on the brief, but I have to put Perlman's name there. But to have 4 more Jewish names on it is impossible. We've got to take them off.
Yeah.
It makes it look like there are a bunch of Jewish lawyers
Like
in
a
the
plot
Justice
cooked
Department.
up by a bunch of Jews in the Department of Justice.
Yeah, I think so.
To the audience, thank you for being with us this time. Be with us again the next time when we will have the second part of the interview with Professor Norman Silber about his book on Philip Elman.